Hello and welcome everyone to the next in our series of lunchtime webinars presented by Hendricks Wealth and Estate Management. Our topic for today is estate planning. Will you trust a trust or will your will with a will? My name is Sean Hendricks. I am our resident estate planning attorney and I am also a financial advisor with Hendricks Wealth and Estate Management. So on this subject, you might ask, okay, who is this guy? Why should I listen to what he has to say? And the reason is I am a licensed attorney. I am a financial advisor. I've had my law license since 2009. I've received my Series 7 and Series 65 licenses and have had those for a good few years. And I've seen some things and I've learned some things in my career that I want to share with you about why estate planning is so important. So there's a lot of reasons. The primary one is that only 32% of American adults have a written estate plan as of 2024. And that number is actually going down. A written estate plan can do some really important things for you. It can reduce the likelihood of estate disputes among your beneficiaries. It can make the passage of your estate to the people that you love much more efficient. And most importantly, it makes sure that you don't leave the distribution of your estate more or less to chance. And we'll talk about the three different ways that you can take, or the three different paths that a person can take when we're doing what's commonly known as estate planning. So before we talk about these things and get into them, I like to talk about these three paths, and we're going to define some things. The three paths essentially are having a will, having a trust, or having no plan at all, or what attorneys will sometimes refer to as intestate succession. So to define each of these terms first, a dictionary definition of a will is a document by which a person directs his or her estate to be distributed upon death. That's pretty straightforward. I like to use plain English, and my definition that I like to use actually is a little broader than that. I would define it as a legal document that names guardians for minor children and provides instructions about how to divide your stuff after death. Because a will actually does both of those things. It can name guardians for minor children, and it can provide instructions, and that might be something important that we're going to talk about later. The next big term that we'll use in this presentation is a trust. And the dictionary definition is a doozy. A trust is a property interest where one person, the trustee, holds legal title to property for the benefit of another person, the beneficiary, arising from a confidence or obligation to use the property as directed by the creator of the trust, the settlor, for a lawful purpose. Whew. Things like that are why people generally don't like attorneys very much. That definition is kind of deep. I prefer a plain English definition, a document that creates a separate legal entity with the purpose of holding property for you or someone else. So when you're creating a trust, what you're really creating is a separate legal entity that holds property for you. And because it does that, it can do some pretty interesting things that we'll talk about in a few minutes as well. The third path, or the third definition that I want to get, is what I like to call no plan or intestate succession. Now, a dictionary defines intestate succession as the legal process by which property is distributed when a person dies without a will. So it's really, if you don't make a plan, the law steps in, and the law will determine what happens with all of your stuff. The plain English version is if you die without a will or a trust, this is the process that the law follows to distribute your stuff. So each of these options can have some different pros and cons. So I'm going to talk for a few minutes about the pros and cons of each path, starting with a will. So a will, which is the document that you draft that is a set of instructions for your stuff, the pros about it is it's pretty easy. You write it, you review it periodically, you keep it somewhere safe, and you don't have to do a lot beyond that. The initial cost for a will is generally pretty low. And a will is the only document that can be used to establish guardianship for children under the age of 18. So if you've got kids under the age of 18, you really, really need a will if you want to make sure that you can designate who would take care of them if you passed away. The cons of a will, or the negatives, are that a will must go through probate usually. Now, probate is underlined there because that's another term that you might hear frequently. Probate is the process by which a court will oversee the administration of a will or the administration of an estate. And the reason that probate exists, and not many people really know this, is that as we are all here, as we all exist, we are our own legal entities. But when we pass away, we cease to exist as legal entities. So your property, the property that you owned, it always has to be attached to a legal entity. Now, if you pass away, if you cease to exist, the court has to step in. It has to create a legal entity, even if it's just a temporary legal entity, called your estate. So, for example, like the estate of John Doe. And so the court has to step in through this probate process to create the legal entity that will hold your stuff, or what was your stuff while you were living, for the duration of the time that the administration process happens until the administration can be finished. And the downside is that this process might be inefficient. It can take anywhere from 12 to 18 months, or even longer if there's a contest or if there's litigation. The probate process can also be expensive. So it may be cost prohibitive in the long run to go through probate. And because a will, it goes through probate, and probate is a court proceeding, documents that are filed in court are available in the public domain typically. So anyone can log in and get information about some of the things that happen during that probate process. So it's not very private. So will can have some good things about it. It's also got some pretty serious cons to consider. Now, if we contrast that with a trust, again, is a document that creates a legal entity for you, and you put some of your property into that trust while you're living. The pros of a trust are it's likely to be more efficient than having a will or no plan at all. It might have lower total costs after everything's said and done. A trust can typically avoid probate. A trust is typically private. Because it avoids probate, it can also typically avoid documents being filed in the public domain. And trusts can be used more effectively for what we refer to as beneficiary planning. And beneficiary planning is underlined there because that's another term that I want to talk about for a moment. When you have a trust, when you create this legal entity that holds your stuff for you, and you put all your stuff in this trust, we can now bypass probate because we've already created the legal entity that holds property for you. We don't need the court to step in and create one for us. So we create this legal entity while we're living. It holds our property for us, and therefore it can bypass that court process. When we do that, we also have the ability to do some kind of interesting things with respect to who's getting what within our estate, and it becomes a little more flexible. And the end result of that process could be that we allocate certain types of assets towards certain beneficiaries in a way that could save the beneficiaries some taxes. So that could be a subject of a whole other webinar, and it goes a little bit beyond the scope of this, but this is something that we often talk to clients about when we're talking about setting up wills versus trusts. So the pros: efficient, lower overall cost, private, and it is more effective for beneficiary planning. The cons are that a trust can have higher initial costs to set up, so you're paying a little bit more on the front end, and a trust requires some work. Once we create the trust, we have to put our stuff in it. Typically, that might mean putting a house into it or titling certain property into the name of the trust, and that takes a little bit of work on the front end too. The third path, what I call no plan or intestate succession, the pros are doing nothing is free. You don't have to pay much to do nothing. It's free in the sense that it doesn't cost you anything. It might cost your estate a lot more. The cons of not having an estate plan or relying on intestate succession is intestate succession usually requires going through probate, unless there are certain limited exceptions. The intestate succession might also result in what I call unintended consequences. By that, I mean someone might get your stuff that you didn't want to get your stuff. And I'll talk about that in a moment too. If you don't make a plan, nobody knows what you really wanted. And finally, if you don't make a plan, your family might be sad because either they think you didn't care enough to do a will or a trust, or that if you just never got to it, they might not know what your wishes were. And as an example, people often think that if they rely on intestate succession, that they say, oh, I don't need to do a will because my spouse is just going to get everything. Well, that may or may not be true. At least in Illinois, intestate succession, I'm actually going to read it from the statute here. If there's a surviving spouse and also a descendant of the decedent, 1/2 of the entire estate to the surviving spouse, and 1/2 to the decedent's descendants per stirpes. All that really means is your spouse isn't automatically getting everything. Half may go to the spouse and half may go to the kids. That might not be what you actually wanted. So if you're leaving it to chance, you're taking a risk with how your stuff might be divided. In addition to having the wills or trusts or using intestate succession, there are a couple other important documents that I like to mention when we're talking about estate planning. And I'm going to refer to documents that are in Illinois. Some other states might call these documents other things. But one of the most important documents in your estate plan that has nothing to do with passing property along is called a power of attorney for healthcare. You might also hear of this document referred to as a healthcare surrogate. In the power of attorney for healthcare, what you're really doing is you're naming someone else to make healthcare decisions for you if you can't make those decisions for yourself. So if you're unconscious in the hospital, you're delegating the authority to make healthcare decisions to another person who hopefully can make educated and informed decisions on your behalf. Similarly, a power of attorney for property, or if I could rename this document, I'd call it a financial power of attorney. You're naming someone else to make property or financial decisions for you if you can't make them for yourself. So again, if you're in the hospital, if you're unconscious, you're delegating the authority to someone else who can, write a check out of your checking account, who could pay your mortgage, for example, who could pay your electric bill for you. And then finally, you might also hear of documents called a living will, or sometimes referred to as an advance directive, which is a set of written instructions regarding your wishes for end-of-life care. A living will can sometimes occupy some of the same territory as a power of attorney for healthcare. So if you have both of those documents, you have to make sure that they kind of play nicely together. But you might hear of those 3 documents as well, and all of those documents are also super duper important when we talk about estate planning. And when I refer to an estate plan, I would not consider an estate plan to be complete unless it had either a will or a trust and at least powers of attorney for healthcare and property. That's how important I think those documents are. So when we're talking about the different plans and what's right, how do you know what's right for you? What are the right documents for you to have for yourself? And these are my guidelines. These are not necessarily written anywhere. These are guidance that I like to give to people when they ask me what documents are right for me. And so for a will, I would generally recommend a will if someone is in the asset gathering stage of life. They're early on. Maybe they've just purchased a home or they're saving up for a home. Maybe they have young children. If your children, remember when I said at the beginning that if you have children under the age of 18, only a will can name guardians for them. So if you're in the early stages of asset gathering, if you have young kids, you're at least going to need to use a will. The arrow kind of really points in that direction. Similarly, if avoiding probate is just not that important to you, meaning, some people will say, I like the idea of avoiding probate, but it just really isn't that important. A will might be the best move for you. Comparing that to a trust, if you are further along, so if you are in more than just the early asset gathering stage of life, you have some assets to protect. You have a house. You have some other assets and tangible property built up. If you want to protect those assets with a trust, And if you like the idea of having your estate administration be more private and efficient, a trust might be the better way for you to go. I personally like trusts because I think it's easier for the beneficiaries, partly due to the increased efficiency. But if the person who's carrying out the instructions under your trust, if they can move along at a decent pace, the administration process might go a lot faster, and that tends to be easier for everybody involved. Uh, Finally, which plan is right for me? I would be very reluctant to recommend no plan or intestate succession. If you really just don't care, if you're the kind of person who throws caution to the wind, or if you slept through this presentation, you might be the kind of person who would use or who would want to use no plan at all or intestate succession. As an attorney, I don't recommend that path, but a lot of people end up there. So, in terms of how do we help clients with this? Well, for starters, we end up discussing these things with clients all the time. As a matter of fact, it's part of our process to talk to them about estate planning, and we help them answer these questions regularly. Um, Having an estate plan that works well together with your retirement plan is kind of a no-brainer. So a lot of people have their estate plan and they have their retirement plan, but they don't always see if those two work together, or they have no retirement plan at all. In my opinion, it is a much, much better decision to make sure that your estate plan and your retirement plan are kind of rowing in the same direction. And what I mean by that is, if when you have an estate plan, you're naming beneficiaries. You're saying, okay, I want to make sure that all of my stuff goes to these people. In your retirement plan, your nest egg that you've spent your whole life building, you can do things like naming beneficiaries on your retirement accounts. And making sure that those two things work together is super duper important. So that's something that we will work with clients on a very regular basis as well. And there are strategies that can potentially save you or your beneficiaries a lot of money by planning in advance. One of which I referred to a little while ago as beneficiary planning, where maybe we looked at the different types of assets that are in your estate, and maybe we direct certain assets towards certain beneficiaries and certain other assets towards other beneficiaries to try to reduce the overall tax burden. And again, that might be a subject for an entire other presentation. But if you want to talk about that, or if that's interesting to you, then I would strongly urge you to reach out and contact us about that, because that's something that we really, really want to help our clients do. So we've now reached the question and answer session. I'm looking, I don't see any questions in the question box, and I don't see anything in the chat either. So I'll give it a moment. But if you're attending this presentation, or if you're watching a recording of this presentation, I would also encourage you to visit our website, www.hendrickswealth.com, and go to the events tab, because we will be doing these presentations on a weekly basis, and typically during lunch times when we're live. And there's a whole list of events that'll be there for you. And I encourage you to register for those events as well. I still don't see any Q&A.
And Sean, if I can interject really quickly, if anyone has any questions, there is a Q&A button down at the bottom, and that'll allow you to type a question for Sean. So while we're waiting for any of that, Sean was referring to the events tab on our website. And to round out the rest of October, next Wednesday, we will have Chris Beisner speaking about traditional versus Roth IRAs, which is right for you. The Wednesday after that, on October 15th, we'll have Tom Anderson speaking about money moves to make in your 20s and 30s. On October 22nd, Jim Hendricks will be joining PADS, which is a charity, a local charity around here, and they'll be speaking about legacy giving and leaving a lasting impact. And then on October 29th, getting into the Halloween spirit, I will be doing a a session on facing common financial fears, a calm approach to investing. All of these webinars will start at 12:30. So here Central Time, it's right around lunchtime. So we want to make sure that these are convenient for our clients and anybody that wants to join them. And they generally only run for what, Sean? We're trying to keep them to about a half hour now, right?
Yeah,
So
we're at about 20 minutes now. And actually,
yeah.
I do see a couple of questions that have come up. So the first question is, what are the first steps to setting up a trust or a will? So the first step would be to talk to someone who is qualified to do either of those things for you. For a trust, typically in initial meeting, I would want to talk to a prospective client about how they could utilize the trust. And we would want to come up with who would ideas for the people that would fulfill the different roles in the trust. For example, who would the beneficiaries be? Who would be the trustee or the person who will kind of carry out the instructions in the trust? And all of these are typically part of a conversation that happens over a period of time. So the first step would be to set up the meeting and inquire. The next step would be to start having a discussion about how we would want the trust to actually work. It then becomes my job to make sure that we draft a trust that will do those things for you. For setting up a will, again, the first step would be to make an appointment with someone who's qualified to set those up for you. And then once we set up a will, it would be a discussion about if you have children under the age of 18, I would want to talk to you about guardians. Who would you want to take care of your children if you passed away? And then also I would want to map out, who would your beneficiaries be and how would you want your property distributed? So those would be the first steps in that part of the process. We have another question that asks, how complicated is it to put something into a trust? Do you need a lawyer for this? I hate to answer questions, but it depends. Some parts of the process can be relatively straightforward, and it depends on the kind of property that you're putting into a trust. For example, if you have your home, your primary residence, the way, at least in Illinois, the way that you put your primary residence into a trust is by filing a deed for your home that transfers the home from yourselves as individuals or from yourself to yourself as the trustee of your trust. And now, if you're familiar with the process of recording deeds, it is something that could be done by someone who's familiar with that process, but I generally don't recommend it because every county has different rules, and even every city has different rules, and it can be a little daunting to someone who's never done it before. So I do recommend talking to an attorney if you're transferring a house into a trust. If it's another type of asset, for example, if you have like a savings account with a significant amount in it, or if you have an investment account, not a retirement account, but an investment account with a significant amount in it, you can do what's called retitling, where you really just you retitle that account into the name of the trust so that the trust is now it now holds that property. Because remember, the trust is a legal entity that we've created, and we put stuff in the trust by titling it in the name of the trust. So a bank account or a brokerage account is something that a financial institution might be able to help you do. So excellent question there. Another question asked, we have an unfunded trust. Does it still exist? So if a trust doesn't have anything in it, it's still, think of it almost like an empty boat or an empty vessel. Meaning, if the trust has nothing in it, it's empty, then if the trust is unfunded simply because you haven't funded it yet, you can still fund it. You can still put stuff into it. If the trust is unfunded because it was used to pass property from someone who was living who passed away, and now that trust is empty and there's nothing in it anymore, that trust ceases to exist because the only people who could add property to it have passed away. So if the creator of the trust has passed away, and that trust is empty, it no longer exists. If it's a trust that you've created and you just haven't put stuff in it yet, that's still fine. And you can still add stuff to it anytime you want. Another good question, if you don't have a will or trust, does the family have to pay money out of their pockets, or does the government take money from the estate? So typically, the administration of the estate and the cost for administering the estate comes out of the estate itself. So if for example, someone doesn't have a will and the administration of the estate needs to happen, typically, if it has to go through probate, the court will appoint an executor, someone whose job it is to administer the estate. And that executor then makes sure that everything gets paid out of the assets of the estate. Now, so it's not necessarily the government taking money out of the estate in that scenario. It is the court directing the executor to make sure everybody gets paid, right? Making sure that debts get paid. You make sure the beneficiaries get paid. The risk you might take is that if you have no plan at all, and this is a really, really good part of this question, if you don't have a plan and if nobody picks up the reins and no beneficiaries for your estate are identified, then you're at risk for that estate to do what's called escheating to the state. It means it just goes to the state. It's unclaimed property. So I don't think that's what anybody wants. I think at a minimum, everybody would want someone to get their stuff, or even maybe just their favorite charity. So that's an additional risk that you take when you don't create an actual estate plan. Then the next question, can an old trust from 20 years ago be altered, adjusted for my family needs now? Absolutely. As long as it's a trust that you created. If it's a trust that somebody else created, you may not be able to amend it because only the creator of the trust is the person who has the authority to amend the trust, typically. So if you created the trust and you want to amend it, the trust itself will generally tell you what you have to do. But in most of the trusts that I create, I make it very easy to change them because we can only predict the future so well, right? We might set up a document today and it might be 20 years. And lo and behold, 20 years from now, the people that you wanted to receive shares of your estate are different. So the nice thing about a trust is it's very, very easy to amend. And if you have questions about that, I'd be happy to take a look at the trust that any trust that you have. And I'll tell you, here's what you'd need to do to amend it. It would just be a matter of making an appointment. So very, very good questions. I appreciate everyone being so engaged. We had another one come in. So is probate something to avoid if you can? Generally, you might want to read between the lines a little bit. I'm not a big fan of sending things to probate. In my experience, and I've had clients take both paths, right? And generally, the beneficiaries, the people who receive the estate, whether the estate went through probate or went through a trust and therefore avoided probate, usually the people who were beneficiaries under a trust said that the administration was easier. Now, that's not 100% of the time, but in my opinion, a trust can do more efficiently and at typically a lower overall cost than what a will can do through probate. And probate comes along with court appearances and sometimes even appearing before a judge, which that's not something that a lot of people really want to do. I generally recommend if you have, I try to think of it as almost like a spectrum. If you are clearly in the territory of needing a will and you have kids who are really young, and so that if you died, you'd have to go to court anyway, then a will is fine. But as you move through life and as you buy property and your kids get grown, if you have kids, or as you accumulated assets, the total value of your property doesn't have to be, in my opinion, all that high before the needle moves from pointing at a will to pointing at a trust. And in that scenario, I do think it's good to avoid probate. I do think that's easier for your beneficiaries. So that's I try to give a gentle nudge when I think when someone's estate probably would be better off using a trust. I'll usually try to give them a gentle nudge in that direction, unless there's a compelling reason otherwise. Um, so all very good questions. And oh wait, there's even one more. How do you avoid probate? Uh, so for avoiding probate, so trusts generally avoid probate. It's not a guarantee. You have to make sure that essentially what happens is when somebody passes away, we look at all of their property. And property that is jointly owned, like marital property, for example, generally will be inherited by the surviving spouse. And that's called joint tenancy, or joint tenancy with rights of survivorship, or in Illinois, it's called tenancy by the entirety. So that marital property generally will go to the joint owner. Once we've addressed all the marital property, then we look to see, okay, are there beneficiaries, or sometimes called TODs, which means transfer on death. And any property that passes by beneficiary or TOD, think retirement account, think life insurance. That will generally go to whoever that beneficiary is. Both of those things can avoid probate. The next question we ask, though, is there a trust? And whatever's in the trust, whatever's been properly titled into the name of the trust, will also avoid probate. And for when we use a trust, generally what we want is we want the trust to handle everything that's left. So by the time the trust administration is done, there's nothing else left. We don't have to go through probate because there's no property left to go through probate, or there's so little property left that the law says, hey, you're below the statutory money limit. You don't have to go through probate anymore. So we avoid probate by making sure that we go through this kind of flow chart or these steps, and we review that to make sure that when you have a trust, there's nothing left after the administration of the trust to necessitate probate by law. So the next question that popped up is, do you still have to go through probate even if you have a will? So under a very limited exceptions, a will is going to end up in probate. If, at least in Illinois, if you do not own any real estate and the total value of your assets are less than $100,000, you can avoid probate through a process called a small estate affidavit. But I don't recommend relying on that, because even if you think that's what's going to happen now, that might not be where you end up. So generally, if you have a will, you should at least consider the likelihood of your estate will end up in probate. Using a trust to create the legal entity in advance that allows you to avoid probate is the preferable way to go with respect to probate avoidance. And then another question: does a trust supersede over a will? It comes first in that kind of hierarchy that I was describing a minute ago. As we move through the process of administering an estate after somebody passes away, first there's marital property or jointly held property. Then there's property with beneficiaries. The next stop is there a trust? And if there's a trust and the trust handles everything, then we don't need the will to do anything. The will doesn't, even if there is a will, it doesn't get used because there's nothing left to administer by that point. So, or if there is, it's below the kind of the statutory minimum. So a trust doesn't necessarily supersede a will. It just comes first in the order. And hopefully if we use a trust, then the will doesn't have anything left to do, or whatever the will has to do is very minimal. So all very excellent questions. I'm glad my presentation only went 20 minutes because we had enough questions to get us past the half-hour mark. Thank you all for the questions. Those were excellent questions, and I'm happy to answer them. Because this isn't necessarily the best forum, if you have other questions that you'd like to ask, by all means, please feel free to call and make an appointment. I'm happy to talk. I'm happy to answer questions. I don't charge for consultations, so if you have questions that you want to ask, by all means, please feel free to email or call. I'm happy to answer. There was actually one final question that came in, and I'll take a swing at this one. It says, does probate dig out unfunded debt? So if I'm understanding this question correctly, there's a part of every estate plan. There's an instruction that instructs whoever is administering the estate to reconcile or pay any debts that exist. So in probate, it doesn't necessarily dig out the debt, but what happens is the part of the probate process involves a publication being made that, this so-and-so person passed away. And any people who claim debts against the estate would have 6 months, at least in Illinois, they would have a 6-month window to make a claim for that debt. So probate doesn't, the executor doesn't actively dig up necessarily debts. They have a responsibility to resolve any known debts, but the probate can result in a creditor crawling out of the woodwork because they saw some publication that advised them that there was that they had a claim to make. So the probate doesn't necessarily, I wouldn't phrase it as digging out unfunded debt, but what could happen is that you could have creditors that you didn't know about who come out of the woodwork, and that would be something that would have to be reconciled. That's coincidentally is one of the reasons why probate sometimes takes longer, because you now have these claims that have to be reconciled, and sometimes you have to negotiate them, and that can take time too. So, all excellent questions. If anyone else has questions, I have to close the questions down now because we have to go. But if anyone else has any questions, please feel free to reach out. And again, if you'd like to make an appointment with us, you can use this email address, info@hendrickswealth.com. You can give us a call. And if you want to register for future presentations, remember, just go to our website, www.hendrickswealth.com/events. There's also an events tab right on our website. You'll see the list there, and we'd be happy to have you attend. Each of you who attended today asked excellent questions, so I'd be happy to hear from you again in the future too. So thank you all very much. Jim, do you have anything else to add?
No, I think that wraps it up pretty well, and hope to see all of you next Wednesday, same time, same different place probably, but same time. So register for next week's event.
Okay. Thank you all very much, and have a great
Take care,
afternoon.
everyone.
Thank you.